That's what I'm wondering. What the hell? Does this look like court to you? That's what I'm saying.
Mr. Reindress, you are not on mute. Please mute yourself.
Good morning. We're on the record in docket 16-02501. That is LAFQ versus Tiffany Anderson. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. My name is Joe Brunette. I'm filling in for Tim Smith on behalf of LAFQ.
Good morning, Your Honor. This is Tiffany Anderson.
All right, this is the time set for a discovery proceeding. I've got it set down as a discovery proceeding. Looks like it's been on the docket. The last time was on October 5th, 2020. Mr. Brunette, how are we proceeding today?
We would like to do a debtor's examination with Miss Tiffany Anderson, if that's acceptable to the court.
It is. What I'll do is I'll swear Miss Anderson in, and then I'll place you both in a breakout room so you can continue with some of the questions, okay?
Okay, thank you, Your Honor.
Miss Anderson, I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury in the forthcoming exam?
Yes, Your Honor, I do.
All right, Miss Anderson, I'm gonna have you placed in a breakout room with Mr. Burnett, who is a representative of LAFQ, in order for this discovery proceeding to proceed. Okay, ma'am?
Thank you.
All right, so I'll have Mr. Burnett and Miss Anderson placed in a breakout room, and then when you're done, just come back into this room, and then we'll place it on the record, okay?
Okay, thank you, Your Honor.
All right, you're welcome. All right, we're on the record in docket 22-02703. People of the state of Michigan versus Jade Wachowski. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Wiskowski, who is standing to my right.
And ma'am, you are Jade Wachowski?
Wiskowski, yes.
Wiskowski? All right. Mr. Whiskey, this is the time set for a final pretrial. How are we proceeding?
Your Honor, we would like an adjournment on this for the reason that Ms. Wachowski would like to be screened for a potential mental health court solution. People are agreeable to that, so we need this put off for her to get screened. And if she was accepted, it would be transferred to the mental health court.
Is that a correct statement, Ms. Sutter?
It is, Your Honor.
So we'd adjourn to the second pretrial. It's set for jury trial on November 18th, November 28th. But we will adjourn for second pretrial to mental health court. Is that Judge Buchanan's court?
Judge Buchanan is sobriety court.
Sobriety court.
Yes, it'd be 55th mental health court as far as I'm aware.
All right. So is that Judge Allen or Judge Hill?
Judge Allen,
Judge
yes.
Allen, okay.
In my understanding of the current timeline, we'd need at least 30 days. I think there's only one person doing the screenings as far as I know.
What's our time frame look like there?
You don't want to know.
Well, I'm not too concerned about the statute, but we'll be into.
It'll be the last week in December, which is the 26th. The problem with the case agent.
Yeah, I'm not too concerned about that.
26th. You're on the 26th. That'll be in the new year.
All right.
January 3rd at 9.
January 3rd at 9, and that'd be a Tuesday, right?
Yes, unless they just now lay this case so she can go into sobriety court or into mental health court. Excuse me.
I think it'd have to be reissued to get into the court, right?
It would be transferred. I'm sorry, you're right.
Yeah.
Transfer.
But let's set it for January 3rd at 9 a.m. right now. And then, Mr. Wisty, if you hear a way that she's been accepted application wise, then we can get started on the transfer earlier than that. So it won't be on that January 3rd docket. All right, so I'll adjourn for second pretrial and petition to mental health court application. That's in 55th. Anything else for the record, docket 22-02703, Mr. Wisty?
Yes, Your Honor, I would like to address a couple of things with the no contact order.
Okay,
The victim here informs me that there has been third-party contact from his mother. Specifically, the defendant has given the victim pictures of the child they share in common that are torn apart in a manner that he's got them here. They're torn as if he believes it's some sort of personal attack. It also could be interpreted that she's tearing off the picture of the child itself and it's just torn to just get the picture of the child, get the other people out of there.
right.
It's deeply concerning to him. Just like being reminded at this time, there's a police report being filed on front of the court regarding it, of the no contact, and make sure that she avoids third-party contact. There's also concern, she does own a firearm. It's understanding that has been given to the third party to be held on to for time. I'd like her reminded, or at this point, we'd like her reminded, ideally, we'd like the gun turned into the police for them to hold it for the time being. But at the very least, we'd like her reminded to stay in contact with the bond conditions.
Yeah, and one of the bond conditions is no possession of a firearm.
Correct.
All right,
So it's just concern that she may get the firearm back at this point.
all right. Ms. Sutter, any comment?
Your Honor, just that Ms. Wiskowski has handed over any firearms to another individual, has no plans to get them forward. And regarding any communications that Mr. Wisty is talking about, I've seen nothing regarding a no contact violation thus far. She has told me that she does occasionally speak to the complaining witness's mother about the child. That is not a violation of the no contact order. The no contact order is between her and the complaining witness, not against her and third parties. She's not, as she's informing me, and she has saved all the messages. She's not telling the mother to tell him something. She's just talking to the mother, asking questions. Is Abriana okay? How is she doing? Things like that, which is not a violation of a no contact order.
All right, well, there are two issues here, okay? You're still under bond, okay, and that can be remanded anytime. Do you understand that?
Yes.
Okay. I would make sure LPD has the firearm. I would have whoever you place the firearm with, it's their responsibility to get it to LPD, all right? That is gonna eliminate that as an issue here. Do you understand that?
Yes.
Okay. So that's the safest play with the firearm, is get it to LPD, all right? That's a condition of your bond. That's not gonna be a flexible condition. Do you understand that?
Yes.
All right, so do that ASAP. The no contact order is really in regards to the victim feeling comfortable in any way they can. And I understand if that somehow makes you feel uncomfortable, that you're going through a third party. But right now, you're the person on the bubble, all right? So whatever's said is going to be said against you, and it's going to lead us to a violation. So you want to avoid that. But just any way you can avoid that. That's just the reality of the situation. What I don't want to is end up back here on a show cause or no contact order because somebody said something about you, and then you're going to say, I never said that. And it's just going to become one of those things. The way to avoid that is just to make sure that you follow the preconditioned bond outlines, no contact, any contact that is perceived to be unreasonable is going to be a problem in this. And it's going to be a problem. I'll tell you what, if there's a no contact order problem in this, it's the first thing Judge Allen's going to look at is whether this is going to be a mental health court petition. So that is my concern too. I don't want any of this to affect your ability to get into mental health court because that's a specialty court and that's something he takes very seriously. And if that's the premise for this, that's the perfect court for you. Okay. But you won't get in if we have problems along the way with bond conditions. Do you understand that?
Yes, sir.
All right. So this will be adjourned to January 3rd. I assume Ms. Sutter can work through Mr. Whiskey concerning the firearm and making sure that that's placed in LPD custody. And then I'm sure Mr. Whiskey will keep me apprised of any no contact order. It's quite a date here till January 3rd. So there should be plenty of time to get you apprised and evaluated for mental health court. Okay.
Yes.
All right. Anything else, Mr. Whiskey, on docket 22-02703?
Yes, Your Honor, this is kind of a reverse of the no contact order. They are still exchanging a minor child. The defender, the victim here would like to be able to physically be involved in the exchanges, but not have any communication. It strains his mother to be involved in the exchanges. So if that could be modified in that way where they can physically have an exchange of the child as an exception, that would be appreciated.
Well, I mean, now we're getting into custody issues, which is a problem.
There is an active friend of the court. There's a filing they're aware of. The victim is in contact with the friend of the court regarding that.
Okay. I'm reluctant to change any bond conditions. They're going to place anybody in trouble here concerning a volatile situation and children being, in the middle of this, my main concern in district court here is to keep this defendant away from the victim and no contact between the two. If friend of the court decides that there's other orders that they find acceptable concerning the children, that's fine. But my main contention is essentially that if this defendant violates a condition and there's any ambiguity in the condition, then this defendant's the one that we're having a show cause hearing on. And it's not the victim in the case that's having the show cause. So what is the current state of the no contact bond?
It's just a full no contact order. And what's going on is they're exchanging the child through the mother.
Okay.
So he'd like to be able to be present for the exchanges due to some difficulty of what's on his mother.
I think it's a bad idea.
Okay.
I really do. I just think it's a bad idea to have both parents in a no contact order with the, until this case is resolved somehow.
So it remains as is for the time.
Yeah, it would remain that no contact order would remain. And then anything that comes out of communication with the child and between custody of the child and what comes out of friend of the court. I think that's the appropriate court. My job is to make sure that the victim and the defendant have no contact with one another. And if we can make arrangements through a third party so we don't violate that bond, that's fine. But until then, it's going to be problematic. You know,
Nothing changes.
Nothing-
This
yeah.
court, if something changes.
right. Not unless somebody from the front of the court contacts our bond that says this is amenable. It's just fraught with
Understood.
all kinds of issues, you know. Ms. Sutter, anything on that?
Your Honor, just that I think it seems a little unwise at this point. I understand the no contact orders to protect the complaining witness. I, as the defense attorney, have a desire to protect my client. I already have some concerns about, as you said, the he said, she said situation, or the she said, and I think it's a deeply unwise idea to put either person in this position.
Yeah, right now, it's just a little too sensitive right now. There's already been somewhat these hints of allegation of violation of no contact order. And if this blows up into a full no contact hearing, then my concern is that it will, I anticipate a problem getting her into the 55th court, which appears to be the best place for her, to me, at least if they're willing to accept it. If not, then we'll figure it out from there. All right. I understand that. I understand the problems that it creates, Mr. Wisty, but I just want to make sure that the defendant's safe and not doing what she's supposed to be doing, and the complaining victim safe.
Understood. Your Honor.
All right. Anything else in this file, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, Ms. Wiskowski, we will see you on January 3rd at 9 a.m. Please, for all our sakes, because please abide by the bond conditions. Because if you're not, the only next step we have for no contact is to remand you, okay?
Yes.
All right, that's all for the record in this file. Mr. Burnett, are you ready on the civil case?
Any other questions?
Yes, Your Honor.
All right. Have you had the opportunity to speak with Ms. Anderson in a discovery proceeding concerning any debtor credit information that needed to be transferred or transferred between the parties?
Yes, Your Honor, we had a good discussion. I would like to put a payment plan that we've agreed to on the record, if you don't mind.
Yes, go ahead.
Okay, Ms. Anderson has agreed to a payment plan, whereas she'll pay $100 a month for the first 6 months, starting on December 15th. And then on June 15th, 2023, it'll go to $200 a month. And then on January 15th, 2024, it'll go to $250 a month. And Ms. Anderson has agreed. She's already in the process of sending us her bank statements as well as her 2021 tax return.
All right. And Ms. Anderson, is there anything that Mr. Burnett said that wasn't a part of some of your discussions?
No, Your Honor.
All right. Mr. Burnett, did you plan to file this up with an order, or is this putting it on the record sufficient for your purposes?
It's sufficient for us. Yes, Your Honor. I would like to request a control date, perhaps 30 days out, maybe 32 days out, just to give Ms. Anderson some time to send us the documents and for us to receive that first payment.
All right, we'll set this probably in a control date in the afternoon. Sure we do. And Mr. Burnett, in the afternoon would be fine, right?
Correct, Your Honor. Yep.
For that control date?
Yes.
I think it's like it. So we'll set a control date of December 27th.
Okay.
At 2 o'clock. Just as a date, and then Mr. Burnett, if you need that date, just leave it on. If not, and things are going well, you can always you can call and we can anticipate that maybe that doesn't have to be in Zoom person, so to speak.
Absolutely, Your Honor. If we receive the documents and everything's going well, we'll call and cancel the court date.
Perfect. Ms.
Okay.
Anderson, do you have any questions of the court concerning this file?
No, Your Honor.
All right. All right. Anything else for the record docket 1602501, Mr. Burnett?
Nothing else, Your Honor.
All right. Ms. Anderson, anything else?
No, thank you, Your Honor.
All right. We're set at December 27th at 2 o'clock. We'll see everybody then until we hear differently.
Thank
Okay.
you.
Thank you, Your Honor.
All right. We're on the record in docket 2200657. People of the state of Michigan versus Shannon Mejia. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Shannon Meha, who is president to my rights.
Ma'am, you are Shannon Meha?
Yeah.
Mejia? This is the time set for a final pretrial on the matter. Mr. Wisty, how we proceed?
Your Honor, we'd like this left on for jury trial. Witnesses are here today. Just so the court is aware, Ms. Mejia's defense attorney informs me we may be filing some motions with the witness list, and there may be some motions in limine. At this point, we anticipate we'll be ready at the trial date. And if we're not, we'll approach the court. and
Okay.
Ask for another adjournment. Just to give the courts a heads up, that would be my intent. Our
And that-
intent to be ready to go that date, but there are some issues we're still working out.
And it's left on for December 5th at 8 a.m.
Yes.
Okay. Mr. Yang?
Yes, Your Honor, that's a fair and accurate statement. I did receive some additional discovery from the people last Thursday. I reviewed that over the weekend, and I believe there are some additional witnesses that I need to disclose to Mr. Wisty. In addition to that, we did discuss some possible motions in limine that I will be bringing. Our goal is to keep it on the 5th. That date is on our calendar, but we'll inform the court ASAP if we need to do that. We just wanted to let you know so that
Right.
as we get closer, you're not wondering why we're jumping this to another docket.
Right. I understand. So at this point in time, we're leaving on for jury trial for December 5th at 8 a.m. And then we'll see if there's any discovery issues that needs to take place.
Yes, sir.
Anything else for the record in 2200657, Mr. Wisty?
No, Your Honor.
Anything, Mr. Yang?
And further, and just for the record, I believe I have everything I need for as far as discovery wise for this case.
Okay,
Just-
perfect.
Just for the record.
All right. So then I'll see everybody on the 5th until I hear differently, okay?
Thank you, Your Honor.
Thank you. We're all on the record 2200657.
Be in touch.
Have a good day.
You too. Ms. Rodriguez, Adela Rodriguez, I see is the, okay, you're the victims on the Mejia case?
Yes.
All right, the case has been left on for jury trial. It's on December 5th, so you're free to leave. If you have any questions, keep in contact with the Assistant Prosecutor, Jake Wisty, okay?
Okay, thank you.
All right, thank you. All right, so we're on the record in docket 1702162, people of the state of Michigan versus Ryan Rindris. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Rindris.
Sir, you are Ryan Rindris. Okay, you'll have to unmute yourself.
Yes.
All right, thank you. This is the time set for a pre-trial, final pre-trial in the matter. Mr. Wisty, how are we proceeding?
Your Honor, our witness is not available. The people will be dismissing.
We have no objection to that, Judge.
All right, Mr. Rindris, this people move to dismiss. So this will be without prejudice. which means that the case for all purposes today is dismissed. The people could reissue later if they feel the need to, or if they have additional evidence, but for our purposes today, the case is dismissed. All right, sir? All right,
Yes.
I will be signing the nollie pros in regards to that. Anything else on the record in docket 1702162, Mr. Wisty?
No, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Rindris, you're free to leave the Zoom courtroom. The case is dismissed.
Thank you.
You're welcome. Oh, let me. Record in docket 1803706, people of the state of Michigan versus Millard Benson. Will the parties please introduce themselves to the record?
Jake Wisty on behalf of the people.
Good morning, Assistant Public Defender Lauren Sutter, appearing today on behalf of Mr. Vincent, who is present via Zoom.
And sir, you are Millard Benson?
Yes, John.
All right. This is the time set for a final pretrial in the matter. Mr. Wisty, how are we proceeding today?
Your Honor, our witness is not present this morning. As a result, the people will be dismissing without prejudice.
No objection, Your Honor.
Mr. Vincent, you understand that the people are moving to dismiss dismiss this case without prejudice. That means that they, in the future, they may, if they have additional evidence, move to proceed on this file, but today the case is dismissed. Do you understand that, sir?
Yes.
All right, Mr. Wisty, I'll be signing a nollie pros in that case.
Yes, Your Honor.
All right. Anything else for the record in docket 1803706, Mr. Wisty?
No, Your Honor.
Ms. Sutter?
No, Your Honor.
All right. Mr. Vincent, the case is dismissed. You're free to leave the Zoom courtroom. We're on the record in docket 2202499. People of the state of Michigan versus Jada Rose Miles. Will the parties please introduce themselves to the record?
Jake Wisty on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Ms. Miles.
And ma'am, you are Jada Miles?
Yes, that's correct, Your Honor.
All right, and you can hear me all right, Ms. Miles?
Yes, sir. Can you hear me all right?
I can, thank you. Mr. Wisty, this is the time set for a final pretrial today. How are we proceeding?
Your Honor, we reached a resolution. Ms. Miles will plead guilty to an attempted retail fraud with a Killebrew, or plead no contest to an attempted retail fraud with a Killebrew agreement. The fines and costs only. She's already on probation in another court. Sentencing from the bench is appropriate in circumstances. And the reason for the no contest is civil liability. And I think the court has a copy of the police report, which would be sufficient for the people for factual basis.
And so it would be the same, it would be the same PAC code number except with an A and then half the penalties. Is that my understanding?
Correct, Your Honor.
So it'd be 750.356 4A with a maximum penalty of, I don't know how to split 93 days. Does that, we just do the 45 day?
Yes, Your Honor.
I mean, yeah, I don't know what the attempt would split it in half. So it'd be half of 93 days under $500. I can split the 250,
It'd be 46.5.
6.5. That just seems so
I think
arbitrary.
there is a court rule dictating whether it's to the benefit of the defense, or not, and I can't remember which way it goes. You're not supposed to split the days,
Okay,
but I can't remember whether you would go 46 or 47.
all right.
I
But-
guess, Your
but-
Honor, given the Killebrew agreement,
Yeah, it's kind of
Right,
moot
she's got-
point.
And the Killebrew agreement is just fines and costs, right?
correct.
But she should know the ultimate penalty of what she's pleading to. So let's make it 46.5 for our purposes, but we'll explain that to her. All right. Ms. Robinson, may I inquire of your client of her advice of rights concerning
You
the
may.
misdemeanor? All right. You've heard the plea agreement. I'll restate it for the record. My understanding is that you're going to be pleading no contest to an attempted retail fraud in the second degree with an immediate sentencing of fines and costs in the matter. That'd be in violation of 750.356 D4 parent A, which means that we cut the penalty in half. So in order to be completely literal, that would be, you'd be facing, if your Killebrew is not accepted and you withdraw your plea, the ultimate penalty in this case can only be half of the original penalty of the which the retail fraud was. So it'd be 46.5 days or 45 days, and or $250, which is half of the original fine. Do you understand that, ma'am?
Yes, Your Honor.
All right. And it's your intention to plead no contest for civil liability purpose pursuant to this file. Is that correct?
Yes, Your Honor.
All right. If your plea is accepted, you'll not have a trial of any kind. This no contact plea, and I'll walk you through your trial rights in this matter. If you had a trial, you'd have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question those witnesses against you. You, of course, are represented by Public Defender Erin Robinson today. She would be present to contest any charges or cross-examine any witnesses that would be brought against you. Do you understand that, ma'am?
Yes, Your Honor.
You'd have the right to have the court order any witnesses to appear in your defense. You'd have the right to remain silent during the trial. You'd have the right not to have that silent used against you, and you'd have the right to testify at trial if you choose to testify. If your plea of no contest is accepted, you'll give up the claim that the plea of no contest was a result of any promises other than the plea agreement or threats that it was not your choice to plead guilty. Do you understand that, ma'am?
Yes, sir.
You'd also be giving up any appellate rights you'd have in regards to a trial because you're not going to have a trial. You're giving up any appeal rights in regard to that. You would be pleading no contest today because that is your choice. Is that right, ma'am?
Correct. Yes, sir.
Okay. So I won't swear you in. I have the case number of Ms. Robinson of 225-190-1339, the police report, in order to take the factual basis for the no contest plea, and the underlying reason for the factual basis would be civil liability. Is that your understanding, Ms. Robinson?
It is, Your Honor.
All right, Mr. Wisty.
That would be my understanding as well, Your Honor.
All right. So let me review the police report. So it appears on the date in question, which is February 8, 2022, at the offense location of 6200 South Pennsylvania, City of Lansing, Ingham County. The defendant Jada Rose Miles, the allegation is, did attempt to commit the crime of attempted retail fraud in the 3rd degree, which would be while Meyer was open to the public, stole property, the item that was offered for sale, price of less than $200. The police report would confirm that this did happen on February 8, 2022, at the offense location of 6200 South Pennsylvania, City of Lansing. And it appears that the defendant was observed paying for was involved in the paying for items that were switched at the register and failed to pay the correct amount for the items. And then it goes on to list what items were failed to pay for in regards to the price switching, and then exited past all sale points by Meyer personnel. It appears that all unpaid merchandise were handed over, and that Ms. Miles took responsibility for her actions on that date. Anything in regards to the factual basis, Mr. Wisty?
No, Your Honor.
Anything, Ms. Robinson, concerning the
No, Your
factual
Honor.
basis? Find the factual basis of the no contest plea to be accurate in regards to the attempted retail fraud for less than $200 with the opposed fine. And then there's no objection to immediate sentencing. Mr. Wisty, is that correct?
Correct, Your Honor.
Ms. Robinson, that's your understanding? No objection to immediate sentencing?
No objection.
All right. Well, I'm going to set, so for the attempted retail fraud today, I'll set fines and costs. $75 for fines, $75 for costs, for a total of $150. I have a crime victim's rights fee of $75 that I can't waive, and a state fee of $50, for a grand total of $150. Equals $425. The nature of the offense, I won't, and pursuant to the Killebrew, we'll do fines and costs only for $425.
Hold on,
Miss
I think that's a little too much if you did 75 plus 75 plus 125.
I
So
think you're
that,
right.
yeah. Just checking on math, I know.
And plus 50, it didn't sound right. It's 275.
That sounds right.
That sounds right. 150, 75, and 50. Yeah. Do Ms. Miles, do you need some time to pay that to the city of Lansing?
Yes, is that a possibility to break that up over like the next two, 3 months?
But I think what I can do is I can let you deal with the city of Lansing in regards to payments, but I can give you some time to make that payment. So would 45 days suffice in order to make that $275 payment?
Yeah, that should be good.
All right. So I'm going to order fines and costs to be paid, that $275 to be paid to the city of Lansing. And I'll give you 45 days to make that payment. I'd much rather set up a plan that works than set up a plan that doesn't, you know.
Correct. And I'm
So
on probation right now in the 55th Mason right now. So
right.
Right, I'm working that out right now. I'm paying, I think, 100 or 200 a month with that.
All right, so it,
I'm so sorry. My dogs are barking. I apologize, Your Honor.
so let's do this in order to avoid any problems between the two being on probation to do, having to owe us and owing 55th. Let's set up our own, let's just set up our own plan, okay? So if you can pay a quarter of it by December 15th, and then we'll just set it up that by December 15th, January 15th, February 15th, to March 15th, you pay a quarter each time. That's
Yes,
just a way of making sure that we've set it up. And so you don't get caught in between both probations. Would
that would
that
be,
work?
yes, thank you.
So let's set it up that you pay $68.75 by December 15th,
That'd be excellent.
$68.75 by January 15th, $68.75 by February 15th, and $68.75 by March 15th. And I think that'll cover the $275 debt. And then it's known to you, so you don't have to get in between both the costs you have at 55th and the costs you have at 54A.
That'd be excellent. And I just go to the city of Lansing, or,
That just goes to the city of Lansing. So by December 15th, make sure that you pay $68.75 to the city of Lansing, either in person or online, and the file will reflect what your payment schedule is.
okay, thank you.
All right. Any questions concerning file 2202-499, Mr. Wisty?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, Ms. Miles, you should be all set. The 15th of the next 4 dates are your payment dates, okay?
Okay, does that mean that I do not have to, because I believe I was scheduled on the 28th of this month as well? Do I not have to do that?
Cancel.
Yeah,
Okay,
that'll be canceled. So this will be the new schedule that you have in regards for this court.
okay, excellent, thank
All
you.
right. All right. Thank you, Ms. Miles. That's all for the record in this file. You're free to leave the Zoom courtroom, ma'am.
Okay, thank you.
Ms. Robinson, were you able to speak with Mr. Castano in a breakout room?
No, Your Honor, unfortunately, there's no sound, and he can't get it to, I guess, on mute, so I'm not sure.
All right.
Tell her to go back out, fix it.
What's that?
Tell her to go back, I'll fix it.
All right. If you re-enter the room, Nathaniel will see if he can fix that.
Got it. Thank you.
You're welcome.
I'm not sure what's going on.
Sir, you're Jerry Braddock. You're here for your 9:30.
Yes, sir.
All right. You're in the right place. We've just got a couple cases to call in front of you.
Okay.
Nikisha, surely you're here for your 9:30?
Yes.
All right. You're in the right place. We just have a few files in front of you. Then the person on Ariana's camera and scroller,
Sorry.
is that you're Miss Salazar?
Yeah, I'm sorry.
That's all right. You're here for your 9:30, ma'am?
Yes.
All right. We have a few files in front of you, but you're in the right place. Stand by.
I thought he said it was on MLK. Mm.
202657. People of the state of Michigan versus Noel Jackson. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing on behalf of Mr. Noel. He is standing to my right.
Sir, you are Noel Jackson? Okay. This is the time set for a final pretrial in the matter. And there was, in the past, there's been a request for interpreter for the language of Kinyarwanda.
Yes.
Kinyarwanda. And so I have it as early as November 1st, there was an interpreter must appear. And then this was going to be transferred to this court. On November 2nd, we've set a new final pretrial, but on November 11th, today we're here and at I assume a final pretrial and no interpreters here. And it doesn't seem that anyone was ordered. So Mr. Wisty, how would you like to proceed today?
Your Honor, I'd like this matter adjourned. Defense and counsel informs me Mr. Noel has court here on the 28th at 1 p.m. Makes sense to have this adjourned to that date to get one interpreter for both hearings at that point.
Is that your understanding, Ms. Sutter?
Well, Your Honor, I suppose what I would first ask is, this is a final pretrial today. Mr. Noel was subpoenaed and appeared. Any witnesses were also subpoenaed and appeared. So I would primarily ask for dismissal of the charges today. There's no witnesses. I don't know how the state can proceed.
Yeah, I don't know how anybody can proceed because we don't have anything. I mean, this whole even the calling of the case and appearances, we don't understand that. So we don't have an interpreter, so he understands this process. I'm assuming he kind of understands what this process is going through, but I understand that this was set for final pretrial and the state's supposed to have witnesses here and they've not. Overriding that problem is the bigger problem that we want to make sure he understands every step in this process. So ancillary to that, does he have another date set?
Yes, the rest of that is correct. He does have a hearing in front of yourself on the 28th at 1 o'clock.
28th at 1 o'clock.
November 28th for probation.
For probation violation?
An arraignment on a probation violation, yes.
So let's reset this final pretrial for that date. And let's have the victim subpoenaed to come in person. Or well, I don't want them both here at the same time. I guess that's, Mr. Wisty, your take on that? Does the victim also need an interpreter?
Yes,
Yeah.
same language is my understanding, Your Honor.
I would know, Your
She
Honor.
appears, but one, I don't know if she's even capable of appearing by Zoom.
Right.
Difficulty of how we explain to her what's going on. We've got our language. I know we sometimes here.
Okay.
I would request that she be allowed to appear on Zoom to avoid him being here. But if
Yeah,
it's
any way that's easiest for her to get here by Zoom and avoid some type of, a violation of the no contact order because we're ordering everybody to be here at once.
Is the interpreter able? Will the interpreter be on Zoom or the interpreter will be physically? here?
The interpreter should be physically present, but we should probably have two interpreters.
It's not a should, it's a must, Your Honor.
Yeah, I think it's a must. Yeah. So I think we should order one interpreter for the defendant and one interpreter for the victim.
My understanding, Your Honor, is it's not the responsibility of the court to order a translator for complaining witnesses. That is the responsibility of the prosecutor's office.
Okay.
The court is only obligated.
That sounds like an accurate statement. So for our purposes, and communicate this to Mr. Jackson as best you can, but we're going to reset this for the same time of the probation violation. So we'll reset final pretrial for same time as PV arraignment.
So it's gonna be November 28th at 1:30.
So it's November 28th at 1:30.
PV as well, or is it PV at 1 and this at 1:30?
We'll set them both for 1:30.
They're
Yeah.
both set for
Yeah.
1:30.
And what is the PV arraignment for? Do we know?
Just a second.
We'll need to order a translator.
I'm sorry, it's gonna be at 1 o'clock.
1 o'clock? Okay.
Probation. So they wanted to lump this in.
His probation violation is for an OWI.
All right. And we'll need to order the translator for that hearing.
Probation should have, but I'm.
And then Mr. Wisty, you'll make sure and get whatever translator and see if you can, if you have an understanding of the victim appearing for that final. We'll just treat that at the same time as a final pretrial.
Thank you, Your Honor.
Right. Anything else for the record? Docket 22-02657, Mr. Wisty.
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right. And you can do your best to convey some of this information to Mr. Jackson, but that November 28th date is when he should appear just for the PV arraignment in general. So that shouldn't change anything.
Correct, yeah.
All right. Anything else for the record? Docket 22-02657.
No, Your Honor.
Thank you. Ms. Sutter?
No, Your Honor.
All right, thanks.
All right, thank you.
Sutter. Ma'am, you are Nazani Wilson Willoughby.
Yes.
All right, I'm gonna wait. Your public defenders, Lauren Sutter, and your case has been rescheduled, but we're gonna put it on the record just so you know and she knows why why we've rescheduled it. Okay.
Okay.
So stand by, and your lawyer's gonna be here too. All right.
Okay. Thank you.
You're welcome. Mr. Robinson, are you ready to go on Mr. Castano?
Yes, I am.
All right, perfect. We're on the record in docket 22-02702. People, the state of Michigan versus Carl Castano. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Castano.
And sir, you are Carl Castano?
Yes, I am.
All right. You can hear me all right, Mr. Castano?
Yes, I could.
All right. Mr. Wisty, this is the time set for a final pretrial in the matter. How are we proceeding?
Your Honor, my understanding is the defendant will be pleading as charged here this morning.
Ms. Robinson, is that your understanding?
That is.
All right. So the plea will be to the count, just so we're on the same information, will be to count 1 domestic assault. Is that correct?
Correct, Your Honor.
Yes, Your
All
Honor.
right, Ms. Robinson, may I inquire of your client of his advice of rights?
You may.
Mr. Castano, you understand that the maximal penalty for what's commonly referred to as domestic assault is a 93-day and or 93 days in the Ingham County Jail or $500 fine. Do you understand that,
Yes,
sir?
I do.
Okay. And it's your intention today to plead guilty to that offense.
Yes.
All right. If you plead guilty, you'll be waiving certain rights in this matter, and I'll walk you through those. Okay.
Yes.
All right. If you plead guilty to the file, you'll be giving up the following trial rights that you'd have at trial. One is you'd be giving up the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, and to question those witnesses against you. You're, of course, represented by a public defender, Erin Robinson, and she would contest any charges and cross-examine any witnesses brought by the state against you. Do you understand that?
Yes.
You're also giving up the right to have the court order any witnesses in your defense. You're giving up the right to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. Do you understand that?
Yes.
If the plea is accepted, you'll give up the claim that the plea was a result of any promises or threats, that it was not your choice to plead guilty. Do you understand that,
Yes.
sir? You'd be giving up the right to any appeal rights that you'd have that coming out of trial. Because we're not having a trial, you're pleading guilty.
Yes.
Are you pleading guilty today because you are guilty, sir?
Yes.
Can I have you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Okay. I'm going to bring your attention back to October 5th, 2022 at 1225 Regent Street, City of Lansing, Ingham County, State of Michigan. Were you at that Regent Street a date on October 5th, 2022?
Yes.
Okay. And do you know a Jennifer Robertson?
Yes.
Okay. And is Jennifer Robertson a resident or former resident of your house, or somebody with whom you had a dating relationship?
Dating.
Okay. The allegation is that you committed an assault upon Miss Robertson. Can you tell me how that happened on that date at time?
Okay. I sat there and I walked in the roommate's roommate's room, and Miss Robinson was sitting there in the other gay roommate's room, and sitting there, you've been kissing. You've been kissing her.
So what did you do in response to that, sir?
I got mad, and I sat there and you punched her.
Okay. And at the time you punched her, you intended to punch her?
Yes.
Okay. Because you were angry?
Yes.
All right. Anything in regards to the factual basis, Mr. Wisky?
No, Your Honor.
Anything in regards to the factual basis, Ms. Robinson?
No, Your Honor.
I find the factual basis for domestic assault in this regard to be knowing, understandingly, and voluntarily made. I think that this probably should go to probation, as you know. So we'll direct the defendant to probation for a pre-sentence report. So I'm going to direct you to probation. You might as well go today if you're still here. If you're here, it's just on the 5th floor.
Yeah, I know.
Okay. So direct to probation on 5th floor. Defendants to go today. And then we will set it for sentencing date. They'll do a report for me and we'll figure out what the sentencing is after I see the report. What's the good sentencing date for this file?
January 3rd.
So sentencing date will be January 3rd at 1:30. And the defendant's directed and will go to probation today. Anything else for the record in docket 2202-702, Mr. Wisty?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Castano, if you go today and they'll do the report and then we'll be all set for January 3rd, okay?
Okay,
All right, thank you.
thank you.
So we're on the record in docket 2202-719, people of the state of Michigan versus Annette Smith. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Smith, who I do not believe is present.
All right. This is the time set for a final pretrial in the matter. Mr. Wisty, how we proceed today?
Your Honor, the people would request a bench warrant, give defense's representations that she's had some contact. We'd have no objection to the court recalling this case if Ms. Smith appears later in the morning.
Ms. Sutter?
That's correct, Your Honor. I have had up until now decent contact with Ms. Smith, and she and I have been calling each other back and forth all morning. We've been unable to actually make contact. So I would request if there's any bench warrant, it have a 48-hour hold on it, and hope that I can talk to her actually sometime today.
I don't know if I can do a 48-hour hold on a domestic assault, but I can certainly put a hold on it till today.
In my understanding, Your Honor, it's within the court's discretion
Okay.
whether or not to order it.
Mr. Wisty, what do you think of the 48-hour hold on it? It appears that Ms. Smith has been in contact with Ms. Sutter, so I'm going to put defendant failed to appear, bench warrant, bond forfeiture, but I will place a 48-hour hold on it. She has been in contact with her attorney. And then Ms. Sutter, then you can bring us up to date on the status of her appearance. But at this point in time, we'll have a 48-hour hold placed on the bench warrant bond forfeiture.
Thank you, Your Honor, because I am concerned that she hasn't received a notice to appear. We
Right.
don't have an address in our file, so I don't know if the court.
Well, and we don't either. She was, at the time of arraignment, she was staying with a friend.
Her son, I believe,
Yes,
Trammell.
Trinell. So, all right. So the 48-hour is placed on the case. 48-hour hold is placed on the bench warrant. Anything else on the record? 22027119, Mr. Wisty.
No, Your Honor.
Anything else, Ms. Sutter?
No, Your Honor.
Thank you.
Get my email.
We're on the record docket 22022947. People of the state of Michigan versus Michelle Simmons. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, Assistant Public Defender Lauren Sutter, appearing today on behalf of Ms. Simmons, who is standing to my right.
And ma'am, you are Michelle Simmons?
Yes, sir.
Okay. Mr. Wisty, this is the time set for a pretrial in the matter. How are we proceeding?
I think this is set for a final pretrial and jury trial, Your Honor.
That's correct, Your Honor.
And jury trial. So date for final pretrial and jury trial.
Final trial is going to be 11/28 at 8:30,
11/28 at 8:30 for final pretrial.
and the jury to follow on December 5th at 8.
And December 5th at 8. So the final pretrial on the case will be November 28th at 8:30, and the jury trial will be December 5th at 8. Are the two scheduling dates. Any questions on that, Mr. Wisty?
No, Your Honor.
Any questions on that, Ms. Sutter?
No, Your Honor.
All right. So November 28th will be the final pretrial and December 5th will be the actual jury trial, okay? Anything else for the record, docket 22022947, Mr. Wisty?
No, Your Honor.
Ms. Sutter?
No, Your Honor.
All right. We'll see you back on those dates, okay, ma'am? Thank you.
So if Your Honor, you want to the court, just on for a second, they'll mail it.
Oh, that's right. You have to.
Yeah. So Miss Wilson Willoughby, we're gonna call your file, your lawyers here, all right? You'll have to unmute.
Thank you,
All
Your
right.
Honor.
All right, we're on the record in docket 22-02693. That's the city of Lansing versus Mazzani Wilson Willoughby. And counsel, your appearance for the record.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, appearing today on behalf of Ms. Wilson Willoughby, who is present via Zoom.
And ma'am, you are Mazzani Wilson Willoughby?
Yes, Your Honor, I am.
You can hear me all right, ma'am?
Yes, I can.
This is the time set 10:30 for what was a pretrial in the matter. And this is a city case that was inadvertently scheduled on a statute date. So we don't have the city attorney here. So this was rescheduled already. And I just wanted to make sure that you knew that, and Ms. Sutter was aware of that, so that I'll give you a date and time that it's been rescheduled for, and then you can leave the Zoom courtroom because your case is not scheduled for today. Do you understand that, ma'am?
Yes.
All right, so your date of city ordinance date that you should appear is November 29th
Okay.
at 9 a.m.
Alrighty.
All right, and Ms. Sutter has that date. And if you have any questions, you can contact with your public defender, Ms. Sutter, but that is the new date and time. All right, ma'am?
Okay.
And I'll give you a call before then.
Okay. Thank you.
All right. Anything else on that file? I saw Miss Wilson will be here. Wanted to make sure that we moved the case so that was not scheduled for today. Anything else, Miss Sutter?
I have nothing further.
All right. Miss Wilson will be, you're free to leave the Zoom courtroom, and we'll see you on the 29th.
Thank you.
You're welcome.
Your Honor, if I may be put into a breakout room with Mr. Braddock.
All right.
I'm popping into Zoom right now.
I think I can
Be
do.
a co-host.
Oh. I'm gonna admit Miss Sutter.
Oh.
Lindy right here. All right. Gonna make you co-host. So, Mr. Braddock, I'm gonna place you in a breakout room with your lawyer, okay?
Okay.
All right.
Okay. All right, can you hear me okay?
Yeah, I can hear you.
Okay, we're still in the courtroom.
All right, we're gonna have you both placed in a breakout room. Ms. Salazar, are you represented by an attorney today?
No.
Would you be amenable to meeting with the assistant prosecutor in an attempt to resolve this case at pretrial?
Sure.
All right, I'm going to place you in a breakout room with the assistant prosecutor, and you can discuss some of the issues of the case, okay?
Okay, thank you.
You're welcome. And then Miss Shirley, are you represented by counsel today?
No.
All right, as soon as Mr. Wisty gets out of the breakout room and then Salazar, would you be amenable to talking to him about some of the issues in your case? He's the assistant prosecutor. All right.
Okay.
All right. So stand by and I'll place you in a breakout room when he gets out of the other breakout room.
Okay.
Right, we're on the record in docket 22-02593. That's people of the state of Michigan versus Ariana Salazar. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
And ma'am, you are Ariana Salazar?
Yes.
Okay, and you can hear me all right, Ms. Salazar?
Yes.
All right, Mr. Wissy, this is time set for a pre-trial in the matter. How are we proceeding today?
Your Honor, Ms. Salazar has provided that she got the animal in question properly licensed in a timely manner. For that reason, the people will be dismissing the charge.
And Ms. Salazar, that's your understanding that you've been able to comply with the statute and people are moving to dismiss this case without prejudice today?
Yes.
All right. You understand dismissed without prejudice means they could bring this case back. I have to tell you that. But for today's purposes, it's dismissed. I know that you had the opportunity to speak with Mr. Whisty in a breakout room. And so the case is dismissed for today. Do you understand that, ma'am?
Yes.
And anything else for the record in docket 22-02593, Mr. Whisty?
No, Your Honor.
Ms. Salazar, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you. Bye.
All right. And Mr. Whisty, did you want to meet with Ms. Shirley?
Yes, Your Honor.
Okay. Ms. Shirley, I'm going to go ahead and place yourself and Mr. Whisty in a breakout room concerning your matters, okay?
Okay.
And so Jake, you would just re-enter.
Excuse me. First floor restroom. It's on the first floor.
So you can re-enter room 3 and I'll put Miss Shirley in there.
Thank you, Your Honor.
All right. So you put Miss Shirley in room 3.
we can go forward on Shirley.
All right. Here's the second in custody or not in custody. Are you? All right, we're on the record in docket 22-02602. People of the state of Michigan versus Nikisha Shirley. Will the parties please introduce themselves to the record?
Jake Westy on behalf of the people.
And ma'am, you are Nikisha Shirley?
Yes.
All right. This is the time set for a pretrial in the matter. Mr. Wisty, how are we proceeding today?
We've reached an agreement where Ms. Shirley will plead as charged. People will kill a brood and no initial jail, just fines and costs. Sentencing from the bench.
All right. So Kilbrew, immediate sentencing, fines and costs only.
Correct, Your Honor. And I do have the punishment if the court doesn't have that readily available.
It's a dog at large. Yeah, what is the punishment on that?
90 days or a fine of not more than $500.
And was that written under the statute or it doesn't?
City ordinance.
Okay,
State and county animal control ordinance.
section 1A. I have AA 9, section 1A. I just want to make sure I've got, what's that?
I defer to what's on the ticket.
Okay. I have it as AA 9, section 1A. But it should be that the penalties should be in pursuant to the Kilbrew agreement. That should be fine. Ms. Shirley, my understanding is you're going to plead as charged to the ticket. It's a misdemeanor. It has the ultimate fine and penalty of 90 days in the Ingham County Jail and $500 fine. My understanding that it's also, there's a Kilbrew agreement that you be sentenced to fines and costs only pursuant to the ticket, and there to be no Kilbrew, no jail, and we would proceed to immediate sentencing on this. Is that your understanding, Ms. Shirley?
Yes.
All right, Ms. Shirley, this is a misdemeanor, so you'll be giving up some misdemeanor trial rights if your plea is accepted. I'm going to walk you through those trial rights, okay?
Okay.
So you'd be giving up the following rights that you have at trial. One is to be tried by a jury. You'd be giving up the right to be presumed innocent until proven guilty. To have the prosecutor prove beyond a reasonable doubt that you are guilty. To have the witnesses against you appear at trial. To question the witnesses against you. You could seek representation, and you have the right to representation to be represented and contest any charges and cross-examine any witnesses brought against you. You'd have of course, to have the counsel present and to be represented. You'd have the right to have the court order any witnesses for your defense. You'd have the right to remain silent during the trial. You'd have the right not to have that silence used against you, and you'd have the right to testify at trial if you choose to testify. Do you understand those trial rights that you'll be waiving today, ma'am?
Yes, sir.
If the plea is accepted, you'll give up the plea that the plea was in the result of any promises other than the plea agreement that's been indicated, or threats, or that it was not your choice to plead guilty today. If you plead guilty today, you'll be giving up any appellate rights that would come from a trial. Do you understand that, ma'am?
Yes.
Are you pleading guilty today because you are guilty, ma'am?
Yes.
I'm gonna have you wave your right hand, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I'm gonna bring your attention back to the date of the misdemeanor ticket, which is September 28th of 2022 at approximately 4 p.m. Were you responsible for a dog named Buddy at the Westmount Hope location?
Yes.
And was the dog Buddy at large on that day in violation of the misdemeanor ticket that was written?
Yes.
All right. I find the factual basis to be knowing, voluntarily, and accurately given. Mount Hope being in the city of Lansing, Ingham County, state of Michigan. Mr. Wisty, anything in regards to the factual basis?
No, Your Honor.
Okay. Ms. Shirley, we will go to immediate sentencing today. So there'll be a fine of $100 and a cost of $100. I have to order a crime victims' rights fee of $75 and a state fee of $50. And if I do my math correctly, and it's $325.
Okay.
Do you need some time to pay that, ma'am?
Yes, I do.
Would your preference be today that I give you, I'll give you a choice today of what works better for you. I could give you out into 4 to 6 weeks to make that payment of $325, or we could devise a plan that would work for you today, that you pay it off in the next 4 months.
What is it? 3 to 6 weeks. It's good.
All right, let's put it out. Let's put it out that the fine can be paid, fines and costs can be paid to the city of Lansing in 6 weeks. So by December 26th.
Okay.
Right,
and
so-
where would I pay it at? Can I pay it online or anything like that?
Yeah, you could pay it here on the 6th floor to the City of Lansing Criminal Division.
Okay.
You can also pay it online.
Okay.
All right. You can also send it in, but either one of those, the criminal division, and I can give you a number for that division if that would help.
Yes. Let me get an ink pen.
Okay.
Oh.
That's the payments, right? So let me give you a number for that.
Okay.
It's 517.
Okay.
483 4435.
4435.
35. And then
Okay.
you can pay online at 54A District Court Pay.
You said
.com.
district court?
Yep, districtcourtpay.com. So 54A districtcourtpay.com.
Okay. And one more question, please.
Sure.
If say for instance, if I can pay it like some of it this Friday, that's when I get paid. And can I do it like in like 2 increments or something like that?
You can, but you'd have to talk to them about it.
Okay. Okay.
Or just make whatever payment you can. You have till the 26th to pay off the full amount.
Okay. Okay.
Okay. All right, ma'am. You're all set. Any questions? Any other questions for me?
No, thank you.
All right. Thank you, ma'am. That's all for the record in this file. Thank you for
Okay.
your appearance today.
Mhm.
All right, we're on the record in dockets 20-03710. I'm sorry. We're on the record in dockets 19-04526 and 20-00175. People, the state of Michigan versus Alex Katz. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Aaron Robinson, Assistant Public Defender for Mr. Katz.
And sir, you are Alex Katz?
Yes, sir.
Okay. This is the time set for pretrial on both these matters, 19-04526 and 20-00175. Mr. Wisty, how are we proceeding?
Your Honor, the offer is a 1-for-1. Mr. Katz will be accepting it. I would defer to the defense counsel to which one, if he has a preference on pleading to. People would not object to immediate sentencing, but there's no killer rule for that. That's acceptable to the defense.
Ms. Robinson, what's your understanding?
Yes, Your Honor, he will be pleading to the older file 19-04526 SM, and in for a successful plea and sentence, then 20-00175 SM would be dismissed, and we would also move for immediate sentencing.
All right.
Just to be clear, people can't agree to immediate sentencing as part of it, but we're not going to object.
Okay.
The court is still inclined.
And Mr. Katz, that's your understanding of the plea agreement?
Yes, sir.
All right. Ms. Robinson, may I make inquiry of your client concerning the advice of rights, misdemeanor rights to the plea to the retail fraud?
You may.
All right, sir, you understand that the maximum penalty if you would plead to this charge, this misdemeanor charge, would be 93 days in jail and or $500 fine. Do you understand that, sir?
Yes, sir.
Okay. And that's if your plea is accepted. If you plead to that case, we won't have a trial. So you'll be waiving the following rights, and I'll walk you through those, okay?
Yes, sir.
Okay, you would have the right to have a trial by jury. You'd have the right to be presumed innocent until proven guilty. You'd have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You'd have the right to have witnesses against you appear at trial. You'd have the right to have to question those witnesses against you. You, of course, are represented by Public Defender Aaron Robinson today, and she would be available to contest any charges and cross-examine any witnesses brought by the state against you. Do you understand that?
Yes, sir.
You have the right to have the court order any witnesses that would come to trial on your behalf. You have the right to remain silent during the trial. You have the right not to have that silence used against you. You have the right to testify at trial if you choose to testify. Do you understand those trial rights that you'd be waiving in order to plead guilty today?
Yes, sir.
If your plea is accepted, you'll give up the claim that the plea was a result of any promises other than the talked about plea agreement or threats that it was not your choice to plead guilty. You'd also be giving up any appellate rights to the trial because you won't have a trial. You'd be pleading guilty. Is it your intention to plead guilty today, sir?
Yes, it is.
You're waiving those rights today. Are you pleading guilty because you are guilty,
Yes,
sir?
I am.
All right. I'm going to bring your attention back. I'm going to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to June 10th of 2019 at the offense location of 6200 South Pennsylvania Avenue, City of Lansing, Ingham County, State of Michigan. Were you on that date, June 10th, 2019, at 6200 South Pennsylvania Avenue?
Yes, I was.
Okay. And you were at Meyer then?
Yes, I was.
All right. And was there property that was open to the public at Meyer? Were they selling stuff at Meyer?
Oh, yes.
Why don't you tell me what you did to make you guilty of the count one?
I went in there and seen some bottles of whiskey and put them in my backpack. And
Okay. And
proceeded to walk out.
and you did not intend to pay for those?
No. I didn't.
All right. And the price of those were less than $200?
Yes.
All right.
Oh, yes.
I find the factual basis to be knowing, voluntarily, and accurately made. Any questions concerning the factual basis, Mr. Wisty?
No, Your Honor.
Any questions on the factual basis, Ms. Robinson?
No, Your Honor, thank you.
All right. My understanding is there's not an objection to immediate sentencing from the people?
Correct, Your Honor.
All right. So I'll set fines and costs on this matter.
And Your Honor, If you are sentencing
like-
to fines and costs, I would just note that he is on SSI, so he does receive a fixed income and to allow for maybe for him to make monthly payments.
Thank you. And Ms. Robinson, do you have any, since we are going to immediate sentencing, do you have any statement on allocution on behalf of Mr. Katz?
Yes, Your Honor. This case is about 3 years old. Since then, Mr. Katz has been doing good. Further, he's also on probation out in 55th, where he's required to report and do services with them as well. Therefore, being on probation in 2 different courts could be a hassle for him and just a waste of resources. So we feel as if Mr. Katz would just benefit from fines and costs, and then we would ask that you make those reasonable as well, because he is on a limited income. Thank you.
Mr. Wisty?
There's no restitution here. I think this probably is a crime rooted in addiction issues. Assuming that'll be addressed in probation in the other court.
I understand that you're currently on probation, so there is some resources. I'm going to set fines and costs, and then some crime victims' rights and states fee that I don't have any say over. All right, but I will give you some time to at least date certain that you know you're responsible for getting the fines and costs paid. We're not going to order any upfront jail or jail in this. And you are on probation, as I understand it, correct?
Yes, I am.
All right. So I'm going to set fines and costs: $100 fine, $100 cost, crime victims' rights fee of $75, and then a state fee of $50 for a total of $325. And then I'll kind of leave it up to you, Mr. Katz, that I can give you a certain amount of time to pay that. And in your circumstances, I would say probably 6 to 8 weeks, something along those lines, or I can divide that into quarterly payments and give you dates certain that
Every
you,
month?
yeah, per month.
Yeah, that'd be fine.
That work better?
Yes.
Okay.
Yes.
So let's divide that 325 divided by 4. So I will order that on December 15th, you pay $81.25. On January 15th, you pay $81.25. On February 15th, you pay $81.25. And then on March 15th, you pay $81.25. And that'll give you a total of $325. At least you have a date certain you need to make those payments.
Yeah, that's fine.
So that'll be part of the fines and cost plan in this.
That'd be perfect.
All right.
And I pay it right here at the 6th floor.
Yeah, you can play it on the 6th floor right here. That's the easiest way. You can
I'll
also
be
go
right there
online
in
and play it.
person.
All right. So anything else on the sentencing in this matter, Mr. Wisty? I think we've worked out a plan, and he'll pay on the 6th floor.
Yep. Nothing further, Your Honor.
Anything, Ms. Robinson?
No, Your Honor. Thank you.
All right, Mr. Katz, you're all set, okay?
Thank you.
Thank you, sir.
All right. Can I get paperwork?
Yeah, as long as you make payment by December 15th, you're good.
All right.
Yep,
December 15th.
December 15th.
$81.50.
Yeah, we'll write that down. $81.50, it's $81.25 by December 15th, January 15th, February 15th, and March 15th.
Yeah, could you write it down?
I got it. I got it.
You got it? Okay.
Write it down for me. Thank you. Thank you, Your Honor.
You're welcome.
Thank you very much.
Thank you. Yeah.
No. There's a bunch of people like ahead of me is what I think. But yeah, I've talked to attorney before, you know what I'm saying?
So we're on the record in docket 22-01268, People of the State of Michigan versus Christopher Fisher. This is the time set for a plea in the matter. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
And this is Public Defender Scott Nickel on behalf of Mr. Fisher, who is present.
Sir, you are Christopher Fisher? All right. This is the time set for a plea. My understanding is we're going to reschedule for a preliminary examination, Mr. Wisty.
That is my understanding, Your Honor.
And Mr. Nickel?
That is correct, Your Honor.
So we'll set for preliminary examination. You can,
11:23
yeah.
at 9.
So it'll be set for 11:23 at 9 a.m. for preliminary examination. Anything else for the record, Mr. Wisty?
No, Your Honor.
And for that, on any comment on that November 23rd date?
What's that?
We're good on that
We're
November
good on
23rd date? All right. Mr. Nickel?
Nothing further.
All right. Mr. Fisher, we'll see you again on November 23rd at 9 a.m. Okay? Thank you.
You're gonna put a note.
So we're on the record in docket 22-02381 and 22-02382. That's people of the state of Michigan versus Jerry Braddock. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Braddock, who is joining us via Zoom.
And sir, you are Jerry Braddock,
Yes, sir.
and you can hear me all right, Mr. Braddock?
Yes, sir.
All right, Mr. Wisty, this is the time set for a pretrial in the matter. How are we proceeding?
Your Honor, we reached a resolution. Mr. Braddock will plead guilty. Case number 22-02381 SM, in exchange the people will dismiss. Case number 22-02382.
Ms. Robinson, I'll restate my understanding of that plea offer for the record. My understanding is the defendant will plead guilty to 22-02381. That is the unlicensed dog ticket. I would think that's count one of the ticket. They're two files separated.
I believe they are
Yeah,
the same ticket.
so that's count one. And my understanding is that is a 90-day misdemeanor and or $100 and or $500. $500 with a plead guilty to that count one, count two is to be dismissed.
Correct.
All right. And this is all pursuant to, it was written as it's written under the state, but I have it written under the Article 7, Section 1. Is that my understanding or?
Article I have it as Article 4, Section 1 of
Okay.
the Ingham County Animal Control.
Article 4, Section 1. All right, may I inquire of your client of his advice of rights concerning this misdemeanor?
Yes, Your Honor.
All right. Mr. Braddock, you understand that you face a possible penalty if you plead guilty in this matter to 90 days in jail and or $500. Do you understand that, sir?
Yes, sir.
All right. If you plead guilty today, you'll be giving up the following trial rights, and I'll walk you through those, all right?
All right.
You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to question those witnesses against you. Of course, you are represented by attorney Lauren Sutter today, and she would be here to cross-examine any witnesses or contest any charges brought up by you against you by the state. Do you understand that, sir?
Yes, sir.
You'd have the right to have the court order any witnesses to testify for you on your defense, on your behalf. You'd have the right to remain silent during the trial. You'd have the right not to have that silence used against you. And you'd have the right to testify at trial if you choose to testify. Simply stated, if your plea is accepted, you'll give up the claim that the plea was a result of any promises other than the plea agreement or threats that it was not your choice to plead guilty. Do you understand that, sir?
Yes, sir.
You'd be giving up any appellate rights that may come from a trial. You're not going to have a trial today. You're going to plead guilty. Is it your intent to waive your rights and plead guilty in this matter?
Okay.
Is that your intent today to plead guilty?
Yeah,
and waive your
yeah.
rights? Okay.
Yes, yes, sir.
And you're all right. I'm going to raise your right hand. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to September 1st, 2022, at the offense location of 1006 Malin in the city of Lansing, Ingham County. Were you a guardian or in charge of a dog by the name of Marley or Marnie? Marley?
I think it's Mark.
Is it Marley, sir?
Harley.
Yeah. Yeah. And you were in charge. You were the custodian, or that dog was in your care and custody. Is that correct?
Yes, yes, sir.
All right. And was that dog unlicensed on that date?
Yes, sir.
All right. And that was in the city of Lansing, Ingham County.
Yes.
All right. Anything concerning the factual basis for plea, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
I find the factual basis for the misdemeanor plea to be knowing, understanding, and voluntarily made. Is there any objection to immediate sentencing in this matter, Mr. Wisty?
No objection.
Any objection, Ms. Sutter? Mr. Braddock, since we're going to set fines and costs in this matter, so fines and costs will be set at $75 fine, $75 costs, for a grand total of $150. There'll be a crime victim's rights fee of $75 and a state fee of $50. And I'll give you a total for that. So that's a total of $275. Do you need some time to make that complete payment, sir?
Yes.
Would 6 weeks suffice?
Yeah.
All right, so let's get a date. 6 weeks. 12/26. So 12/26 at 5 p.m. So so that total will be due December 26th at 5 p.m. to the city of Lansing on the 6th floor. Okay.
All right.
All right. Any questions regarding the sentence, Mr. Wisty?
No, Your Honor.
Any question of the sentence, Ms. Sutter?
No, Your Honor.
Mr. Braddock, do you have any questions of me?
Nope.
Okay, you're all set. It'll be due December 26th by 5 o'clock. Thank you for your Zoom appearance today.
Yep.
All right. And the second file is dismissed pursuant to the plea agreement. That is files 2202382, which really was the second count on the ticket.
Yeah, there's always weird things with it.
Yeah, I'm not certain how that works.
I've tried to look into it. I haven't figured out the logic yet.
Oh, I'll tell you the line.
I'm in here, right? I am in here, right? I am on this, right?
Yeah.
Yeah, Mr. Patterson, we're almost with you. We're just taking care of some files before we get to you, okay?
Okay, I'm sorry. I was talking to the CO. I'm sorry.
Rob, you're good. You're right where you should be, sir.
Okay, thank you.
Miss Robinson, Miss Sutter's going to cover the writ out with the interpreter here, just so we can get it all done here in person, okay?
Oh, okay. I mean, you could just put them on an iPad and I'm happy to do it.
What it causes a problem because we end up with the interpreter, the defendant, and Nathaniel all together on an iPad, which creates, it's just too many people on the iPad to do it effectively. So, but we got Miss Sutter here, and I think that would probably makes it a little easier. So if do you need to speak with Miss Sutter about the case at all?
No, not at this time.
All right. Just so you know, we're handling the case.
Oh, okay. Thank you.
All right, so we're on the record in docket 22-02740, 22-02980, and 22-02740, which is a pay 53 as to one of the companion cases. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Patterson, who is present with us via Zoom.
And sir, you are Scott Thomas Patterson?
Yes, sir.
All right. And you can hear me all right, Mr. Patterson?
Yes, sir.
All right. This is the time set for a pre-trial on two of these matters and then a PA 53 hearing on the other. Mr. Wisty, how are we proceeding today?
Your Honor, we'd like the underlying matters set for a final pre-trial and a jury trial. Regarding the PA 53, the people don't have witnesses at this time. Dismissing it at this time.
Okay.
Yeah, yes, reserving the right to bring it back if we do have a cooperative witness at a later date.
All right, so we'll set the two main files, 22-02740 and 22-02980 for final pretrial and jury trial.
Your Honor, I suppose I'll just make the effort since we're here. The complaining witness, Ms. Burtis, was subpoenaed today and did not appear. I imagine the same thing is going to happen for a final pretrial. So I'd ask if she didn't appear on a subpoena today, that we dismiss not only the PA-53, but the two underlying charges as well today.
Mr. Wisty, any response?
Your Honor, I believe the court's without authority to do so. These are set for final pretrials for purposes of the court managing its docket. People would not be willing to dismiss at this time and objects to, simply don't believe the court has that authority.
I even if the witness is subpoenaed, I'm going to be reluctant to dismiss the case other than final pretrial when I know that that's when it's set for. So the objections, the request is noted. And we'll set for final pretrial on
November 28th at 8:30.
November 28th at 8:30.
And jury trial December 5th at 8.
December 5th at 8.
And we're not scheduling the 53, correct?
We're not.
Thank you, sir.
So both files are set for November 28th at 8:30. And December jury trials are set for December 5th at 8 o'clock. So in regards to both of those files, any questions, Mr. Wisty?
No, Your Honor.
Anything in regard to those files, Ms. Sutter?
No, Your Honor, thank you.
And then in regard to the PA-53, it's my understanding is the people are moving to dismiss the PA-53.
Yes, Your Honor.
Without prejudice, the complaining victim failed to appear. And so that'll be dismissed without prejudice. So Ms. Sutter, may I make inquiry of your client concerning the without prejudice?
Yes.
Mr. Patterson, you understand that we did have a hearing, no contact order violation. The complaining victim appears to have not appeared. And so it's going to be dismissed today without prejudice. Do you understand that, sir?
I think so. Yes.
Okay. The other two files are set for November 28th at 8:30 and December 5th at 8 o'clock. If you have any questions in that regard, please keep in contact with your attorneys, Lauren Sutter. Okay.
Your Honor, I apologize. Just if I may, Mr. Patterson was being held in custody for the PA-53 violation that's being dismissed today. May I address bond with the court?
Certainly.
Thank you. As I said, he was being held on a remand until today's PA-53 hearing, and given that that's being dismissed today, I would ask that the court set a bond for Mr. Patterson. I understand that there's going to be no contact order. I believe he was on a GPS tether at the time, so I assume that would be ordered once again. But I would ask that Mr. Patterson be released. He's not staying in jail for another month.
Mr. Wisty?
Your Honor, it is accurate that we don't have their PA-53 to continue. I think that somewhat necessitates the court readdressing bond. These are domestic violence cases. There are two relatively close together involving the same victim here, Your Honor. It did appear to be, that would be the nature of PA-53, the second complaint. Just requests or keep those things in mind when issuing monetary bond.
Well, there was a no contact order. The bond was originally set on both these. And now there's two files and a violation that's been dismissed. Bond was set on the second file at 10,000, 10%. And on the first file at 5,000, 10%. And I'll reset bond on both of them because I've known that we're working on a remand with the same bond conditions of no contact and GPS. But I'll set them both at 10,000, 10%. So bond has been reset. He's not on remand for the PA-53 violation, but it has been set at the higher amount concerning the two files. Anything else for the record, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
No, Your Honor.
All right, thank you. Mr. Patterson, you're all set. We will see you on November 28th for final pretrial and December 5th for jury trial. If you have any questions, please keep in contact with your attorney, Lauren Sutter, okay?
Yep.
And I'll schedule a meeting with you, Mr. Patterson.
All right, thank you. That's all for the record in both of those files.
So I'm done.
You're all set, Mr. Patterson. You're all set. Thank you.
Based on November 1st, she was in custody.
Okay.
I'll check
Yeah.
and see if she still is somewhere.
I don't know where, I don't think she is. I think she made it, but she's got more than one case going on. Yeah. What? So we're back, we're on the record in docket 20-03710. People of the state of Michigan versus Alyssa K. Hill. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
And this is the time set for a pretrial in the matter. Mr. Rothstein is not here, and nor is Ms. Hill, who's the client. There was a previous defendant failed to appear and it was placed on 48-hour hold. There's also, but there's an indication that there's more than one file in these matters. At least one in this county, and at least one in this 54A, and there might be one in 55th.
There is.
So, Mr. Hill, Mr. Wisty, how did you want to proceed today?
When is your next date in this court? Do we know that? The felony file should be up on. That's not this Friday.
Oh, I don't think it is.
Her exam is scheduled for November 23rd.
23rd.
Sure, I would be requesting a bench warrant at this time.
Okay.
No objection to the
48-hour hold. Okay. Yeah, for whatever reason, I don't know that dates got mixed up or anything, but that's easy to place so the defendants failed to appear, bench warrant, bond forfeiture, and that I placed a 48-hour hold on that. Since the lawyer's not here, it makes me fear that there was some type of misunderstanding as to the date. Anything else for the record? Docket 20-03710, Mr. Wisty.
No, Your Honor.
All right, that's all for the record in that file. How about on Stit? Is that your client or
That's
Miss
Robinson.
Miss Robinson?
And back here or
Yeah.
okay.
And is Miss Stitt here? I'm not sure. Avani.
No.
All right. Let's go on the record in that file. So we're on the record in docket 21-02246. People, the state of Michigan versus Avani Janaya Stitt. Will the parties please introduce themselves for the record?
Dick Whiskey on behalf of the people.
Aaron Robinson, Assistant Public Defender on behalf of Ms. Stitt.
This is the time set for a pretrial in the matter. Mr. Wisty, how are we proceeding today?
Your Honor, my understanding is that Ms. Smith is not here. Request a bench warrant. People would have no objection to a 48-hour hold in this case.
All right, Ms. Robinson?
Yes, Your Honor, we would just ask if any bench warrant is issued that that a 48-hour hold be granted in the case. Looks like there might also be some issues with the phone number that I have. Do you have a phone number ending in 0765?
I do.
Okay, just checking to see if we had the same one. Thank you.
I do, and I have no, I'm gonna issue a DFTA bench warrant bond forfeiture. I will note for the record with a 48-hour hold that there is that appears that there's prior fails to appear on summons, but not for a court date. But I do have a fail to appear, but I have, this is an MDOP. I don't have any problem with a bench warrant bond forfeiture with a 48-hour hold in regards to this file. Anything else for the record, Mr. Wisty, on docket 21-02246?
No, Your Honor.
Anything, Ms. Robinson?
No, Your Honor, thank you.
Right, thank you. We're all set. Mr. Perone, you're here on Miss Orta.
That is correct.
Have you had the opportunity to speak with the assistant prosecutor on the file?
I have not yet.
All right, I can put you in a breakout room with Mr. Wisty and you can talk about the case if you'd like.
I would like to be able to.
All
I
right,
appreciate
so
it.
I'll place, so I'm gonna place you and Mr. Wisty in a breakout room. So we're on the record in docket 22-02806, People of the State of Michigan versus Tierra Horta. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Jacob Perona Orta, who is appearing via Zoom.
All right, ma'am, you are Tierra Horta,
Yes, sir.
and you can hear me all right, ma'am?
Yes.
All right, thank you. This is the time set for a pre-trial on a OWI. Mr. Whiskey, how are we proceeding today?
Your Honor, we'd like this set for a final pretrial. I don't know if the court needs to set for a jury trial. I think this will likely resolve at the final pretrial negotiations. are continuing.
All right, let's go. We'll go ahead and set for final pre-trial. So we don't need a jury trial date.
November 28th.
So November 28th at 8:30. And Mr. Perone, you're all set with discovery issues?
I am. I still need to get the in-car videos, but beyond that, they should be able to get those pretty quickly.
All right, perfect. All right, we're gonna set it for final pre-trial on November 28th at 8:30. Anything else for the record, Mr. Whiskey?
No, Your Honor.
Anything, Mr. Perone?
Nothing further, Your Honor.
All right, thank you. Ms. Orta, we'll see you back here November 28th at 8:30. Please keep in contact with your attorney, Mr. Perone, if you have any questions, all right?
Okay, thank you, sir.
All right, thank you. That's all for the record in that file.
Thank you, Your Honor.
Thank you. All right, we're on the record in docket 22-02770. Will the parties please, and we have an interpreter. Let me swear in the interpreter first. So, sir, what is your name?
Felix Paysabu.
Okay, and how do you spell your last name?
N is Nancy, D is David, A is Apple, Y is Yellow, I is ice cream, S is Sam, A is apple, B is ball, Y is zero, E is elephant.
All right. All right. Thank you, sir.
You're welcome.
I'm going to have you raise your right hand. Do you solemnly swear or affirm that you'll make a true and understandable interpretation to the defendant and for the hearing, and you'll accurately interpret the statements made by the witness to the best of your ability? Thank you, sir. All right. So let's go ahead and call the record again. And now we have the interpreter present. So docket, we're on the record in docket 22-02770. And that's the people of the state of Michigan versus Karangwa Haramana. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Assistant Public Defender Lauren Sutter on behalf of Mr. Herrera Mana, who is standing to my right with his interpreter.
And sir, you are Karangwa Haramana.
Yeah.
Okay.
Yep.
This is the time set for a pre-trial in the matter. Mr. Wisty, how are we proceeding?
Your Honor, we've reached an agreement where the defendant will plead no contest as charged with an agreement to time served, restitution to be reserved. And the reason for the no contest plea, as I understand it, is lack of memory and no intoxication.
In Your Honor, I would just clarify, lack of memory. I don't know, and I wouldn't specifically say for intoxication.
Okay, just lack of memory. Okay. And what will I be using as the for the factual basis? What?
Lansing Community College Police Report, case 22886002227, and I just emailed Ms. Holden that document.
All right. And Ms. Sutter, is that your understanding of the what we're doing here today?
Yes.
And so I'll restate that for the record. My understanding is that the defendant's going to plead no contest as charged. And that the no contest plea is applicable because of lack of memory. And the Killebrew agreement is time served.
Correct.
May I inquire of your client of his advice of rights on this misdemeanor plea? Do you understand, sir, that that there is a sentence, there is a Killebrew, there's a plea agreement in this? But the ultimate penalty you could face in this matter is 93 days in jail and or $500. That's yes? Okay. If you plead guilty today, you'll be giving up the following rights, and I'll walk you through those rights. Okay, you have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you appear at trial. You have the right to have those witnesses questioned by you by your lawyer. Your attorney today is Lauren Sutter from the Public Defender's Office. And she would, of course, be able to cross-examine or contest any charges brought against you by the state. You have the right to have the court order any witnesses that you may want for your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. If you plead guilty today, you'll give up the claim that the plea was a result of any promises or threats that it was not your choice to plead guilty. The only thing we've talked about is the plea agreement so far. If you give up the right to your trial today, you'll be giving up the right to appeal any issues that come out of the trial. Is it your intent to plead guilty and waive all those trial rights today? Yes, okay. And are you pleading guilty because you are guilty?
Well, just to
I'm
clarify.
sorry, are you pleading no contest because you don't remember the event? Okay. So I'm gonna refer for the factual basis to, so make sure I have the right, it's case number 22886000227. That is a Lansing Community College report, and that'll be the basis for the factual basis. Is that correct?
Correct, Your Honor.
All right. So I'll find that this occurred at Speedway on 1201 North Cedar Street, City of Lansing, Ingham County, State of Michigan. It was that was a business open to the public with items for sale. And this occurred on October 14th of 2022. It appears that the defendant, Mr. Karangwa, stole items that were for sale to the public. It looks like a couple of cases of beer. And it was addressed at the time that he didn't pay for the items. So I find the no contest plea to be, as far as the factual basis for the no contest plea for the retail fraud third, to be knowing to be accurate concerning the police report. Any questions concerning the factual basis, Mr. Wisty?
No, Your Honor.
Any questions concerning the factual basis?
Other than
Ms.
just
Sutter?
to note, there is no factual basis needed for a no
Right.
contest
It's
plea.
yeah. The factual basis is provided by the police report to the no contest plea.
No issue there,
No.
Your Honor.
All right. And my understanding is, do we have a date for time served on this matter? So I can, because there's no objection to immediate sentencing, correct, Mr. Wisty?
No, Your Honor, I guess when we were reserving restitution, there may be some restitution.
Did you just want to set it for a restitution hearing, or do you want him to go through the probation process?
I would be comfortable with simply a restitution.
Okay.
Your Honor.
I agree with that, Your Honor.
All right, then. And will we be writing him out for that date also?
Zoom would make more sense if Kalamazoo was willing to comply with that.
They're not.
Well, then I don't think we have a choice.
Yeah.
Unfortunately, no county jails will participate.
Yeah,
in
they're
Zoom any
just
longer.
not.
It's helpful of them.
Right. All right. So let's set the sentencing date. Is it time served as date of sentencing?
I would be the time served right now, Your Honor.
All right.
We could do no upfront jail on this one.
But we still have to prepare the writ.
Correct.
Yeah. All right. So the sentencing date will be,
We're not referring to probation.
we're not referring it to probation.
Mr. Wissy, how long do you need to get restitution information, do you believe?
2 weeks should suffice.
Let's do 9:20, I'm sorry, 11:28 at 8:30.
Okay, 128, 830. So let's do this first in regard into sentencing. I'm going to waive fines and costs. Okay. And so I can't waive the $75 crime victims' rights fee and the $50 state fee. So there's a $125 fee there, and be sentenced to time served. And then we'll address the $125 at sentencing. That'll be
Or the restitution.
at the restitution hearing. Why don't we do that? So that'll make more sense since we're coming back here anyway. So the 125 will be addressed at sentencing. And sentencing is set for November 28th at 8:30.
Sentencing or restitution?
Restitution hearing.
Okay.
Yeah.
And Your Honor, I suppose just to be mildly helpful, so he technically would only be owed a day of credit. The court has the not obligation, discretion to give him credit for the other time he served. He has been in Kalamazoo since the 14th and will continue to be so.
So it'd be 2 days.
Is he, yes, that he is absolutely owed.
Okay. So it'd be 2 days time served on this file.
Correct. The court could choose to give him credit for the time he has been serving in Kalamazoo. He's technically
Okay.
had a PR bond in this case, so that math is up to the discretion of
I
the court
see.
to give him or
I
not.
see. Mr. Wisty, any comment on that?
I think credit for 2 days is fine, given.
I think credit for 2 days, and that'll be so time served will be 2 days credit. But we'll rid him out of Kalamazoo for the restitution, just so we have a confirmation on that. All right.
Thank you, Your Honor.
Anything else on record 22-02770, Mr. Wisty?
No, Your Honor.
Anything, Ms. Sutter?
I have nothing, Your Honor.
All right. And so we'll see him back here. We'll rid him out for November 28th at 8:30, just to verify that what restitution is in this matter, okay?
Yes. Thank you, Your Honor.
All right, we're all set. Thank you for your appearance today, sir. Thank you for your help today, sir.
Thank you.
Okay. And then here's the police report for the
Thank you, Your Honor.
no contest. Peebles? Is that you or Miss Robinson?
Assuming he's not on Zoom.
No.
You go take a little walk.
All right.
I've talked on the phone a couple of times.
We're on the record in docket 22-02701. People of the state of Michigan versus Lewis Peebles. Will the parties please introduce themselves for the record?
Jake Wisty on behalf of the people.
Good morning, I think, Your Honor. Have Assistant Public Defender Lauren Sutters on behalf of Mr. Peebles, who is standing to my right.
And sir, you are Lewis Peebles?
Yes, sir.
Oh, all right, Mr. Wisty, this is the time set for a pretrial. How are we proceeding today?
Your Honor, my understanding is defense will be filing for a forensic review in regards to competency.
And that's an accurate statement, Ms. Sutter?
It is, Your Honor. I do intend to file a petition for competency and criminal review evaluation. Criminal responsibility, not criminal review.
All right, competency and criminal responsibility. And those orders will be, that packet will be sent to our court.
Correct.
To move on.
Yes.
Okay. And you've explained that to Mr. Peebles.
I have.
Okay. So at this point in time, this is essentially placed in abeyance on some level. We'll get the paperwork from Ms. Peebles. I'll sign the orders and then we'll be off for the evaluation.
Correct.
Any questions, Mr. Wisty, on that process or a comment on the case?
No, Your Honor.
Ms. Sutter?
No, Your Honor.
All right, Mr. Peebles, you've already talked to Ms. Sutter today. They're going to forward some paperwork and then there's going to be a scheduled evaluation, okay? All right, that's all for the record, docket 22-02701.
Thank you, Your Honor.
Thank you.
Hello? 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 Can you all hear me okay?
Mr. Beck, you're supposed to be here in person.
I was,
Judge told you that last time.
no, you just told me you'll see me in a week.
He told you in person, and it's on the Zoom paperwork. I mean,
I
the
don't
notice to
know.
appear.
Oh my God. So I have to leave work?
He told you to appear in person, and you were supposed to be getting an attorney.
My attorney, I just talked to them this morning. They said that somebody was supposed to be there with me.
Okay, let me check on that, please. Who's your attorney, Mr. Beck?
I didn't know. I just spoke with some lady this morning.
Who'd you speak with?
I called the number again. The first person that picked up the phone. I've been leaving them. I left them messages. They never called me back. I've been trying to call them and finally got a hold of somebody today. Because it said that on the message, on the answer machine, it said they'll call me back in 24 or they'll call me back the next business day. They never called me back. So I called them back.
It's on the record in docket 22-00682. People of the State of Michigan versus Jonathan Beck. The parties please introduce themselves for the record.
Jake Wisty on behalf of the people.
And sir, you are Jonathan Beck?
Yes, sir.
All right. Mr. Beck, you appear to be without counsel today. And I've checked the public defender's indication, and they have no evidence or statement of you contacting their office.
I just spoke with them this morning at 10 o'clock.
But this was actually has been reset from, well, let's see how many times this has been reset.
Once.
October 24th, it was reset. November 7th, it was reset. So this is the third reset for you to get a lawyer.
I really don't even understand. Like, I dropped
Well,
twice.
I have an idea, Mr. Beck. Why don't you come in and see us in person right now?
I'm at work.
That seems to be a problem, doesn't it? This is the third adjournment for you to get a lawyer, and the public defender has no indication that you've applied to their office. I'm running out of options with you.
Do they have is their office near, do they have an office? I go to their office.
Well, I think you should be more concerned about coming to court.
I am coming to court. Listen,
No, I
dropped
mean live
twice.
in person, the way we discussed the last two times.
You didn't.
And your notice has in person too on it, doesn't
I
it?
don't have a notice.
Well, how did you know to come today?
I just went on because you guys told me last week.
And we said to come in person so we could have a hearing and you'd have a lawyer.
I didn't.
You're not in person. You don't have a lawyer. I'm really running out of options with you.
I really didn't.
All right. So, and we can pull up the prior. We can pull up what I told you previously. That's all on the record.
Yeah. Yes, I'm serious. I really did not hear you say in person. You just said I'll see you next week.
Well, now you failed to appear for a hearing.
I'm not
so
trying
I don't know
to
what to do with you.
I'm not trying to fail you to appear for a hearing. I'm trying to be there. I listen. I dropped.
You want to have a hearing now? We can have it now. You can be on Zoom and we'll have the hearing right now.
Without an attorney?
I think you've been given every opportunity to get a lawyer, Mr. Beck. I don't know how to help you in that regard. I honestly don't know how to help you in regard to you being a grown-up individual and unable to get a lawyer over the last 6 weeks.
I have been a grown-up individual. I drop twice a week. I got to go see my other PO, and then I'm taking all this time off work. I'm going to end up being fired.
You're definitely going to get fired when you go to jail.
For what? For dropping when I'm supposed to be?
For not coming to court in person. I don't know this. I don't know how many times you've been arraigned on probation and were told to be here October 24th, November 7th. You were told to be here in person for today's hearing date, which is November 14th at 1:30. I'm just running out of options with you, sir.
But I honestly did not hear you say in person, or I would have.
All right, Mr. Beck, let's do this. You're to appear in person next Monday. All right. Can you repeat that after me?
Next Monday.
Okay. And you're to appear in court with or without a lawyer. You're in charge of that. All right. But we're going to have a hearing at 1:30 next week. And we're going to do it live. We're going to do it in person. It's going to be a probation violation hearing.
Okay.
All right. So tell me you understand that, so there's no misunderstanding.
Next week, 1:30 in person.
Next week, 1:30 in person. I'm going to indicate that I've put this is to be live in person. A hearing. It's completely upon you now that you've been here 3 times that to get a lawyer, because I don't know what else I can do for you. You have the number. You said you spoke to him this morning. I'd usually give you the number. But now you've told me all that several times. So quite frankly, I know you know how to get a hold of him and get a lawyer. For some reason, it's not happening and I can't explain it to you, but you can show up with or without a lawyer next week and you can explain it to me, okay?
Okay.
All right, so live in person, TV hearing.
What's its address, George?
All right, defendant may or may not be represented depending on what he does. I'm not sure, I'm not certain at this point. What's your home address and we'll send you notice.
1733 South Hollywood.
1733 South Hollywood, that's Lansing, Michigan.
Hollyway.
Hollyway. What's that? Okay, so it's the current address, but just for the record, 1733 South Hollyway, Lansing, Michigan. And what's the zip code there?
48910.
Okay, 48910. And I'm just going to put in the file that we're having a hearing that date. And it's in person. I'm going to make the same notes I have for the last time the last time we got together.
Okay, thank you.
So do you understand that regardless whether you're represented by counsel or not, we're going to have a hearing at 1:30 next week?
Yes.
And that hearing is live. You understand that, sir?
Yes.
All right. Any questions, any misunderstandings, any ambiguity about what we're doing next Monday at 1:30?
No.
All right. Mr. Wisty, you have to be here, so you don't have a choice. But you got that date. We're just going to set it on for next Monday.
Yes, Your Honor.
All right. All right. That's all for the record. Docket 22-00682. Mr. Beck, we'll see you next Monday at 1:30.
All right. Thank you.
Thank you. All right, we're on the record in docket 22-01254. That's People of the State of Michigan versus Michael Mayberry. This time set for sentencing. Will the parties please introduce themselves for the record?
Thank you, Your Honor, and good afternoon. Jared Austin appearing on behalf of Mayberry stands present to my right.
And sir, you are Michael Mayberry?
Yes, sir.
All right. This is time set for sentencing today. Mr. Austin, have you had the opportunity to see the pre-sentence report done?
I have.
any additions, deletions, or corrections to the pre-sentence report?
No, Your Honor, thank you.
All right. Any allocution?
Yes, Your Honor, thank you. Mr. Mayberry has limited criminal history. He's currently under supervision with this court for a drug charge. As far as I'm aware, Your Honor, Mr. Mayberry is in good standing with that probation that he is currently on. He's had his assessment done on that and is doing testing and is following through with what he needs to on that. I don't have any reason at all to believe that compliance is going to do anything other than continue a term of probation for this offense. I would ask the court to adopt the recommendation and to have Mr. Mayberry be on probation to run concurrent with the probation that he is currently on, and to not impose any further upfront incarceration at this point. Thank you.
Thank you. Mr. Mayberry, anything that you'd like to say to the court before the court passes the sentence?
No, just that I remember what you told me last time I was here, so I've been keeping that in mind to keep me on a straight road.
All right. Well, I'm glad my words didn't fall on deaf ears, Mr. Mayberry.
Okay.
But everything here looks like a good recommendation. Okay.
Okay.
In my opinion, everything looks as solid as for the recommendation. I want to see exactly from the file. But I'm inclined also to agree with your attorney, Mr. Austin, and to go with the recommendation. And I understand that there's a punitive element to this just because of the money involved. All right. I know incarceration on one level, but that's part of the practice here of probation. So do your best as a part of probation to make sure that you're taking care of all your responsibilities. I'm gonna take the recommendation. Okay. I'm gonna place fines and costs on the lower end because I understand that you're currently, but I want this to be somewhat of a wake-up call in regards to all that's going on. So in regards to the guilty plea of domestic assault and the allocution of your lawyer, I'm going to suspend 365 days. It's up to a year in jail. Okay. Okay. Credit is given for 1 day served, and then I'm going to suspend the rest upon a successful completion of probation. All right.
Okay. Thank you, sir.
And I see this as this is what we're meant probation. You're not a kid. So you know to dot your I's and cross your T's, and we'll get through this. All right.
Yes, sir.
The restitution is for 12 months. It's $30 a month. Okay, so that's $360. Okay. There's a crime victims' rights fee of $75 that I can't waive, and a $50 state minimum court cost of $50 that I can't waive. I'm putting you on the lower amount of fines and costs for this crime. So it's $150 fines plus $150 costs plus $75 plus $50 plus $360 for probation. So it's a total of, I gotta do it again because I messed up. 300 plus 75 plus 50 plus 360. That doesn't sound right. Plus 50 plus 75 plus 300, 785. So I have a total of 785 that can be paid as a part of probation because you're on probation for 12 months. You're to have no contact with Tanya Krebs, as stated before. Yes, there's no assaultive threatening behavior, no use of possession of alcohol, marijuana, or controlled substance. Doesn't seem to be an issue. Has continued not to be an issue. Okay. Submit to random PBDs at the request of the probation agent. No bars or nightclubs, and not purchase any firearms. If that context you're able to take care of, stay on probation, then you and I don't get to see each other, which is a good thing, right? Yeah. You know, I mean that's the best is that you don't want to spend your Monday afternoons here. Yes, sir. Is there anything about my sense that you don't understand, sir? No, sir. All right. So the total probation cost at the end of the day will be $785, and I'll let you figure out the cost of that with the probation officer. All right. Okay, sir. All right. Any questions, Mr. Austin?
No, Your Honor.
All right. I almost want to double check my math, but is it right? Okay. All right, Mr. Mayberry, good luck to you, okay?
All right.
All right, take care.
Thank you.
All right, thank you, Judge.
All right.